G'day everyone, and welcome to the second video in week 6 of our admin law course. This week we're looking at the broad ultra vires grounds for review. These occur when the decision maker has the power to make the decision, but they make an error when they're doing so. In the first video, we looked at an error of law, where the decision maker misunderstands the actual law they're meant to be applying. In this second video, we're going to look at evidence. Before we look at the rules though, there are a couple of important things to understand. First up, even though we use the word evidence, the rules of evidence do not apply in administrative decision making. This was confirmed in a case called Irving and the Minister for Immigration. Now, some of you may not yet have completed your evidence subject, but those of you who have, an administrative decision maker is not required to consider admissibility rules at all. They can consider hearsay. They can consider opinion. Often the vast majority of their evidence will be documentary, and none of the rules about the admissibility of documents will apply. So when thinking about administrative decisions, put aside the rules of evidence. Second, remember that the hearing rule of natural justice will apply to all these decisions. So subject to the restrictions that we discussed last week, all of the evidence that was relied on by the decision maker should be shown to the person affected by the decision. Okay, so what are the evidential grounds on which a decision can be challenged? First up, Section 5(2)(a) of the ADJR Act says that a decision maker must not take an irrelevant consideration into account. And Section 5(2)(b) says that a decision maker must take into account all of the relevant evidence. Those two requirements dovetail together quite nicely. The decision maker must ignore any irrelevant evidence and must take into account any relevant evidence. That means they can't just conveniently ignore evidence that goes against the decision they intend to make. Naturally, the next question is, well, what do we mean by relevant? Now, I've just said that the rules of evidence don't apply to administrative decision making, and that's true. But there's still some useful stuff in evidence law which can help us, and one of those things is the definition of relevant. In evidence law, evidence is relevant if it's logically capable of affecting the likelihood that a fact in issue is more or less true. So to be relevant, something doesn't have to be a golden bullet. All it needs to do is be logically capable of moving the decision maker's mind in one direction or another. So let's imagine that our decision maker is inspecting the logbook of a young driver. Now, the rules say that at least 10 hours must be completed while driving at night. The decision maker notices that a lot of the claimed night driving hours are between 5 p.m. and 6 p.m. So the decision maker pulls up the Bureau of Meteorology pages to check the sunrise and sunset times on those days. Can you see how this is relevant information? It affects the likelihood of the decision maker deciding that the minimum number of night driving hours has been completed. On the other hand, let's imagine that our decision maker held the view that fathers were not great driving supervisors. And so our decision maker decides to ignore any driving hours where the father was the supervisor. Can you see how this would be taking into account an irrelevant consideration? Most of the forms of discrimination, gender, age, sexuality, race, are irrelevant considerations for most decisions. Relevant and irrelevant considerations also vary from decision to decision. The disability status of a person would be irrelevant to their application for registration as a teacher, but it would be absolutely relevant to their application for funding under the National Disability Insurance Scheme, the NDIS. The race of a person would be irrelevant to their entitlement to a driver's licence, but very relevant to their entitlement to participate in, say, an Indigenous employment scheme. If a decision maker refuses to consider relevant evidence, or if they take into account irrelevant material, then their decision is invalid. The thing is, though, all they have to do is take some account of the relevant material. Two cases, one called Our Town FM against the Australian Broadcasting Tribunal, and another one called the Minister for Aboriginal Affairs against Pico Wallsend, both made it clear that the bar is low. We are entitled to expect decision makers to take some account of relevant evidence, but if they attach less weight to that evidence than we would like, that's not an error in the decision-making process. In the Our Town case, the holders of a radio licence were objecting to the grant of a new radio licence for an additional competitor station. They claimed that the tribunal did not sufficiently consider the evidence of the concentration of ownership in the media in the area if a pre-existing operation obtained an additional licence. The court found that these criticisms were very valid. There was clearly a lot of sympathy in the court for the position being held by Our Town, but the tribunal had given some consideration to the evidence of concentration, and that was enough that the decision was not invalid. The second big rule relating to evidence is found in Section 5(1)(h) of the ADJR Act. A decision can be reviewed if there was no evidence or other material to justify the making of the decision. This rule completely bamboozles many students for good reason. I'll try to make sense of it. It helps to think of this as the rule which operates if there has been a big mistake about the meaning of the evidence. If I say to the decision maker, I have a driver's licence, but they misunderstand me and they believe I was saying I have a motorcycle licence, then their conclusion that I was entitled to ride a motorcycle would be invalid because there would be no evidence to support it. They just simply thoroughly misunderstood the evidence. Let's look at a real life example. In the Minister for Immigration and Al-Miyahi, the Refugee Review Tribunal refused to accept that Mr. Al-Miyahi was from Iraq. Their reasoning was that he had claimed in an interview to be from the city of Alamara, but he was unable to tell them much about that city, and some of his other statements seemed to conflict with the idea of him being from Alamara. In fact, though, it turned out that he had never claimed to have been from Alamara. He'd actually claimed to have been from a much smaller place called Ali Ash-Shaki. Now you can see that if the tribunal had refused his visa because they didn't believe his claim of living in Alamara, the decision would have been invalid. You can't make a decision against somebody's interests on the basis that they made a statement that they never actually made. In this particular case, even though this fact was wrong, there were other reasons not to grant the visa, and so the court found against Mr. Al-Miyahi. Can you see the way the rule works though? If a certain fact is crucial to the decision, and it turns out that fact is just misunderstood by the decision, then there's no basis for the decision. Generally speaking, in a no evidence situation, there's not going to be any need to take action in a court or a tribunal. When it's pointed out that a decision maker has fundamentally misunderstood the evidence, they'll often just back away from a decision and change it. Now, here's the bamboozling bit. Back before the ADJR Act was introduced, there was a common law rule, which was also called the no evidence rule, and it was quite different. Remember how in week 4, we talked about the fact that sometimes the existence of certain facts is a precondition for a decision being made? Well, the old school common law no evidence rule said that if there was no evidence of those preconditions being met, the decision couldn't proceed. Completely different to the modern rule. So if you're reading really old cases and they mention the no evidence rule, you're actually reading about a completely different rule. You'll tie yourself into knots. Okay, so that's the end of the second video. We now know that a decision is invalid if it's affected by an error of law. We know that decision makers must take into account all of the relevant material and none of the irrelevant material. And we know that a decision is invalid if there's no evidence of a key fact that the decision maker has relied on. In the next video, we're going to look at decisions which are invalid because of improper behaviour by the decision maker. Free to go.